Okay, a lot of people are talking about due process, something I've been chasing most of my life. Okay, so I want to go over the due process clause with you, the 14th Amendment. Okay, there's also other places that I'll direct you to, or what I'm going to read to you will direct you to. Okay, the due process clause. Well, the 14th Amendment guarantees that states cannot deprive individuals of life, liberty, or property without the due process of law. The clause ensures fair procedures and protects fundamental rights, acting as a vital check on state power. Okay, in some of my previous videos, I tell people you got to learn this, you got to know this, because it's not going to happen if you don't demand it. You got to go in there and fight as if your life, liberty, and pursuit of happiness counts on it, and it does. It always does. That's what legal reform is about, teaching you what you need to know, because you're on your own. Okay, that's why they have the term ineffective assistance of counsel, and that's what I'm going to teach you. Here's a more detailed breakdown. What is it? What it does. The due process clause prohibits states from unjustly infringing on individual rights, such as the right to fair trial. If you don't have effective assistance of counsel, you have ineffective assistance of counsel. Ineffective assistance of counsel can clearly be stipulated as defective assistance of counsel and destructive assistance of counsel, because ineffective assistance of counsel is described in the Rule of Professional Conduct and Code of Judicial Conduct, and any violation of such rules or codes are mandatory to report by both said attorneys and judges, and nobody does that, and it's mandatory. So that's basically violating the oath, and they took the oath to due process, see to it it's their constitutional duty to see to it that this happens. So it's not only your constitutional right, but it's their constitutional duty, everybody in that court, to see to it that this happens. Okay? It's the law. It's violating the oath. Violating the oath, what? Remember, I told you in my other videos, it's mandatory. Violating the oath is mandatory fines, removal from public service, and incarceration. There's a federal law against violating the oath. This aspect requires a state follow procedures when depriving someone of life, liberty, and property. This includes a hearing, impartial decision maker. Substantive due process aspect protects fundamental rights. Even if procedural safeguards are in place, the government cannot infringe on these rights, even if provided procedural protections. Examples of substantive due process: Supreme Court has recognized fundamental rights like the right to marry, the right to use contraception, the right to privacy as part of substantive due process. Extensions of the Bill of Rights to states. The Supreme Court has used due process clause to extend protections from the Bill of Rights to the states, process known as incorporation. Protection against state action. The 14th Amendment's due process clause specifically applies to actions by state government, not the federal government. The 5th Amendment has a similar due process clause that applies to the federal government. Okay, question asked here, what is due process in simple terms? In simple terms, due process clause ensures that government treats people fairly and follows established rules and procedures before taking their life, liberty, and property. It's about fundamental fairness in legal proceedings. Elaboration: no unfair actions. The due process clause prevents the government from acting unfairly and arbitrarily against individuals. Okay, so some people ask, do these immigrants, everybody see the whole process of anybody accused of any criminal act is required to go through due process. There was no stipulation or limitations on who is allowed due process. It's just guaranteed. Fair procedure requires the government to follow fair procedures before taking action that affects someone's rights to a fair trial, notice of legal actions, and chance to present their case. Okay, that's where effective assistance of counsel comes in, or ineffective assistance of counsel. Protecting rights. Due process helps protect individuals' rights, including the right to a fair trial. If you don't have effective assistance of counsel, you didn't get a fair trial. If you didn't get a fair trial, due process didn't exist. Okay, due process helps to protect individual rights, including the right to a fair trial, the right to be presumed innocent until proven guilty, and the right to a public trial. Now, if you have a right to a public trial, why do they forbid cameras in the court? You ever wonder that? It's because they're consistently breaking the rules in the codes on a consistent basis. You know, even being rude, ignorant, degrading, you know, using in the preamble and the Code of Judicial Conduct will explain it more, but judges don't act accordingly. If you read the Code of Judicial Conduct, I mean, they literally get away with violating the Code of Judicial Conduct as well as the rules of professional conduct, and as well as lawyers. It's mandatory to report in both rules and the codes. Nobody does it, so that's why you are where you are. That's why I'm trying to show you what due process actually is. Okay, due process helps protect individual rights, including right to a fair trial. Okay, I read that. Applied to both federal and state governments. Okay, anytime you go in any court, before you step before a court, before you talk to a lawyer, always look up the rules of professional conduct and the Code of Judicial Conduct. Take them, print them out, study them, highlight every issue you want to discuss, and when you go to court, make sure that that judge plays by the Code of Judicial Conduct and every assurance that the lawyers play by the rules of professional conduct, and if any violations occur, it is the legal requirement, the legal obligation, their constitutional duty to report violation of the rules of professional conduct, as well as violations of the 6th, 5th, 4th, 14th Amendment. Okay, so so we're gonna go from there to here. Okay, letter of the law. A lot of people will tell you in the legal community, you know, what you read doesn't mean what you think it means. Let me give you my legal explanation, what it means to me. And lawyers and judges don't like me because I always refer to the letter of the law. I said you may continue as long as you don't avoid the letter of the law. Anything you say must be within the confines of the letter of the law. Okay, the letter of law refers to exact wording of the law or rule, strictly interpreted without regard its underlying intent or purpose. It emphasizes adherence to the literal text of the law. Even in doing so, might be impractical to lead to unintended consequences. The phrase is often contrasted with the spirit of the law, which considers the border principle and the objectives of the law. Here's more detailed explanation. Little interpretation. Letter of the law prioritizes the specific word used in the legal document, disregarding any broader context or intent. Strict adherence. It requires following the law precisely as written, leaving little room for interpretation or flexibility. Letter of the law. Now, when people speak of the spirit of the law, you can easily refer to justice must be served. Okay. Spirit of the law can refer to truth, justice. And the only way you're going to get that is if you follow the letter of the law and the spirit of the law when it comes to due process, specifically effective assistance to counsel. Okay, but I always use the letter of the law, and judges and lawyers don't like it. Okay, but when interpreting anything written, always refer to the letter of the law. Please, you'll understand as we go in. And they'll try to inject the spirit of the law, telling you what somebody meant when they read it. No, that's not what I see. That's not what I hear when I read it. Simple as that. In the public interest, of course. Look up the public interest doctrine, people. And when we get to the rules of professional conduct, you'll easily understand. Okay, what does the Constitution say about the public trust? The U.S. Constitution doesn't specifically find the public trust in a single clause, but it does establish several principles and structures that relate to the concept. The Constitution emphasizes the public service. All lawyers and judges are public service servants. And lawyers like to say, no, I don't work for the public. No, when you're a lawyer, the law requires you to put the public interest first. And working within the courts, you're working within the public trust. Thus, any officer of the court is a public servant. Requiring officials or prioritize loyalty to the Constitution and the public interest over personal gain. It also outlines mechanisms and accountability and checks and balances, ensuring that those in public office are responsible for their actions. Accountability and impeachment. The Constitution allows for the impeachment and removal from office of officials who violate the public trust, such as those who betray the oath or commit treason, bribery, or high crimes and misdemeanors. Public service oath. Article 6 of the Constitution requires all federal officers to take the oath or affirmation to support the Constitution, underscoring their commitment to the public interest. It means putting public interest first. Okay, putting we the people first before their own themselves. Checks and balances, the systems of checks and balances between legislative, executive, and judicial branches is designed to prevent any branch from abusing its power and betraying the public trust. So that's basically a separation of powers. Okay, that's what they're talking about. President can't tell the courts what to do. Courts can only define the law, interpret the law. Well, you should know about the separation of powers and what their all legal boundaries are. Public trust and structural principles. Some legal schools argue the Constitution, through provisions like the property clause, implicitly recognizes public trust doctrine, limited government power over public resources, inquiring their preservation for the public. That's in the public trust doctrine. It's a requirement that they protect all that. Your water, your air, your land, keeping you from having microplastics in your body. State level public trust, which the federal Constitution explicitly defines public trust. Many states have adapted their own versions of the public trust doctrine, particularly in relation to natural resources like navigable waters and submerged lands. What is the public trust doctrine in the Constitution? The common law trust doctrine protects sovereign lands such as tide and submerged lands and beds of navigable waters for the benefit, use, and enjoyment of the public. These lands are held in trust by the state of California or statewide public, or not just California, but they always mention California. Okay, so what does the Constitution say about the public trust? So remember, the legal system is part of the public trust if you research the public trust doctrine thoroughly. Okay, the Sixth Amendment assures the right to counsel. Yes, the right to counsel is guaranteed by the Sixth Amendment. The United States Constitution. This amendment ensures that all criminal prosecutions, the accused has the right to have assistance of counsel for their defense. And I would have to argue that that needs to be changed to anybody in any court of law have assistance of counsel if they cannot afford it. It may not be a criminal case, but what they do is criminal if they're depriving you of life, liberty, and pursuit of happiness, when taking away your property, your children, taking children away from parents, parents away from children, minus informed consent. And as we all know, or all you know in the legal system, before anything can proceed in a court of law, informed consent is required. And in order to give informed consent, one must have reasonable knowledge to make an informed decision to give informed consent. And how can they give informed consent if they have no such knowledge of what I've already spoken of and what I'm about to speak of? Here's more detailed explanation. Sixth Amendment is part of the Bill of Rights and protects the rights of individuals in criminal cases. It should protect their rights in every case. When people are forced to go pro se, not just in criminal cases, but in civil cases, child custody cases, the judge requires them to abide by the rules of professional conduct, or code, the rules of professional conduct, follow all legal procedures, basically holding them to the knowledge, the wisdom of a legal, seasoned professional, knowing that they don't, assuring that they'll lose. How about it'll be much easier if the judge says, listen, before you go pro se, we're going to go over the rules of professional conduct, the code of judicial conduct, so that way you have the beginning, in part, of what would be considered reasonable knowledge. So that way you can you have reasonable knowledge to make an informed decision, so that way we can get that informed consent from you, so we can continue with this persecution. Minus informed consent, that's persecution. No matter what court that is. Right to counsel, that right means everyone accused of a crime has the right to be represented by a lawyer. And their kids have been taken away because of one thing or another. So basically, you're being accused of a crime. So people, okay, effective assistance. Okay. So people said, no, you only have a right to counsel, but they never actually read this part. Effective assistance. The right to counsel also includes the right to effective assistance of counsel, meaning a lawyer must provide competent and adequate legal representation, which is described in the rules of professional conduct. That's the rules of professional conduct are not only effective assistance of counsel, but also a legal requirement, a constitutional duty of your lawyer to abide by and enforce the rules of professional conduct and anything contained therein. Okay? And that's what we're going to get to. Public defender. If a defendant cannot afford a lawyer, the government is required to provide one, often through a public defender. So people, especially you really got to get with the rules of professional conduct when you have to deal with a public defender. Because a public defender, I've tried to help people from just signing that little piece of paper and walking out. And I had to inform them that they were walking out with a felony if they leave, and provoke them to asking for probable cause hearing. Sometimes the judge grants it, most of the time they don't. Most of the time they send it off to trial. But public defenders, state's attorneys, judges, they don't like probable cause hearings. I mean, that's first and utmost. Whether you have a public defender or a private attorney, that's the first thing they should ask for, is a probable cause hearing. But they don't. That costs money. Even some public defenders will charge you for it. Okay, I've experienced that. Does the Sixth Amendment assure the right to counsel? What does the Sixth Amendment guarantee? We already went over that. Guarantees several rights to individuals accused of crimes, including the right to a speedy and public trial, and that has a statute of limitations on that, which is 90 days, which everybody's always has their right to a quick and speedy trial denied. It's not even offered. It's not even offered. If you don't demand it, be lucky that you get it. Be lucky. The right to a the right to a speedy trial, an impartial jury. I've helped people to get pick an impartial jury by picking the jury themselves. Finding, talking to their peers, people that have been through same issues. Judges and lawyers objected, but they couldn't stop them. This is right. The right to be informed of the charges. Most people wind up in court and don't even know what they're being charged of, and a whole lot of people wind up getting charged multiple times for the same crime, which is violating the double jeopardy clause. But nobody brings that up. Nobody mentions it. And the right to legal representation, which your right to legal representation is a right to effective assistance of counsel. What triggers a right to counsel? The Sixth Amendment right to counsel when formal adjudication proceedings such as formal charges, preliminary hearing, indictment, and information of an arraignment has been initiated against a suspect. And that's why I see arraignment have been initiated against a suspect. So no, that goes. I always tell people, inject that when it comes to right to counsel in family court. Most of the time they will give you counsel, but you won't get effective assistance of counsel. You'll get defective, destructive assistance of counsel. Once these proceedings begins, the right to counsel applies to critical stages of criminal prosecution. Okay, so let's move on. The Sixth Amendment guarantees right. Constitutional duty. So I was telling you, it's the constitutional duty of all lawyers and judges to abide by, enforce, and report any violations in the rules of professional conduct or the code of judicial conduct. This is called due process, folks, okay? And that's what we're going to go over, the rules of professional conduct and the code of judicial conduct, which there's supposed to be zero tolerance to, but they tolerate anybody violating the rules and the codes. So it's up to you. It's up to you. A constitutional duty is a responsibility or an obligation imposed by the Constitution or country or organization that outlines the duties and responsibilities of government officials, branches in government, and even citizens in upholding the principles and the laws outlined in the Constitution. Some people wonder why I take the Constitution wholeheartedly, but you says even citizens, as citizens, when we pledge allegiance to the flag, we don't pledge allegiance to the government. We don't pledge allegiance to a political organization. We don't pledge allegiance to a politician or a political party. We pledge allegiance to what the red, white, and blue stands for, the United States Constitution, and whom it was written to serve and protect we the people. And I first read the Constitution when I was 10 years old. And an epiphany hit me. It's what I used to listen. As a kid, I was interested in politics. People made fun of me that. But I'm a religious person. Sometimes my mom would listen to religious radio on Sundays. A lot of times we hear about Martin Luther King. When he said he had a dream that one day our country will live up to its creed. And I read the Constitution and I thought to myself, in a nation of laws, in a land where it says that all men are created equal, and that all are endowed by their Creator with certain inalienable rights, that among these are the rights to life, liberty, and pursuit of happiness. Imagine being 10 years old and knowing that ain't happening. That hurts. That hurts. Ever listen to his speeches? Somewhere I read, we have the freedom to assemble. Somewhere I read, we have the freedom of speech. Somewhere I read. Yeah. The Constitution, my friends. Okay, so constitutional. Okay, constitutional duty, okay? Like I said, the enforcement of constitutional duties can depend on specific content and nature of the duty, according to scholar comments. Beyond government, some scholars are exploring the possibility of applying constitutional duties horizontal, meaning that private sectors might also have constitutional duties of each other. I mean, come on, as an American citizen, violating the Constitution, that's un-American. Constitutional duties refer to specific responsibilities and obligations assigned to various branches of government, and their official duties is outlined by the U.S. Constitution. And right now what we're seeing is definitely not a separation of powers. I've always believed we should have a separation of powers because when it comes to the Constitution, I've been known to be a constitutionalist. I'm devoted to the Constitution because I'm devoted to who it was written to serve and protect. Okay, let's go over the rules of professional conduct. Illinois Supreme Court. I'm in Illinois, and some people in other states. All you got to do is just type in the rules of professional conduct, and you'll find the rules of professional conduct for your state. I'm going to Illinois because I'm in Illinois. Okay, Supreme Court order. Okay, so we're going to get into the preamble, but I just want to go over the rules real quick. Now remember, these are laws in a court of law. Competence. A lawyer is required to be competent. Okay, competence. A lawyer provides competent representation to the client. Competent representative requires a legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Legal knowledge and skill. Okay, people, you're going to have to go over that. That's not too long. In determining whether a lawyer employs requisite knowledge of skill and particular matter And let's just say that they are competent, but uh, devoid, them representing to you, devoiding their responsibilities set forth in the rules of professional conduct, is acting in an incompetent manner. Okay, what you'll understand as we go along. Diligent. Okay, this is a law. Okay, so it's impossible. I told people before, it's impossible to violate one rule of the rules of professional conduct without violating another. So you violate one rule, you're actually violating multiple rules. And if the rules are violated in a court of law, so is the code of judicial conduct. In the court of law, it's impossible for anybody to violate the rules of professional conduct without the code of judicial being violated, because in the code of judicial conduct, it's mandatory to report any violations, not just in the code of judicial conduct, but also the rules of professional conduct. It's the duties, the legal obligations of all lawyers and judges to report any violations in the rules or the codes. Okay, so you violate one, you violate both. They're intertwined. One cannot exist without the other. Okay, let's go over diligence real quick. A lawyer shall act with reasonable diligence and promptness in representing a client. A lawyer shall pursue a matter on behalf of a client despite opposition, obstruction, personal inconvenience, or a lawyer, and take whatever lawful and ethical measures as required to vindicate a client's cause or endeavor. A lawyer must also act with commitment and dedication to the interests of the client, with zeal and advocacy upon a client's behalf. A lawyer is not bound, however, to press for every advantage that might be realized for a client. For example, a lawyer may have authority to exercise professional discretion in determining the means by which a matter should be pursued. A lawyer's duty to act with reasonable diligence does not require the use of offensive tactics or procedure that, sorry, my vision is blurred, preclude in treating all persons involved in the legal process with courtesy and respect. Okay, I'm going to count on you to read the rest, but diligence doesn't happen, and I'm quite sure you'll agree. There's a lot of, but where is it? It used to be right up there. Let me double check. Diligence. They keep changing this. The more I use it, the longer I've used this. I've been using this since 1979. And what made it easy for me to understand that a lawyer not doing any of this is because in the preamble, when I first read it, preamble says a lawyer's responsibilities. They got to do all this, but they don't do it. But the opening statement clearly stated any violations of the rules of professional conduct and the code of judicial conduct is ineffective assistance of counsel. That's what made it so easy for me to understand. And effective assistance of counsel is guaranteed in the Sixth Amendment of the United States Constitution, and as well as the state constitution, because any law that violates the U.S. Constitution is null and void. It can't exist. So I mean that okay. So I think that pretty much says it itself. Okay, but I used it so much in the 80s. I think that's why they took it out. But why would they take it out? And here I would say because that's in the interest of the bar. Legal professions, relative autonomy, carries with responsibilities of self-government profession has a special responsibility to ensure that its regulations are conceived in a public interest. And not furtherance of parochial interests or self-concerns of the bar. Every lawyer is responsible for the rules of professional conduct. A lawyer shall also aid in securing the observance of lawyers. Neglect of these responsibilities compromises independence profession of the public interest which it serves. Now, if you look up the public interest, it'll take you to the public trust, and it clearly stipulates that the legal system and all that it employs, officers of the court, are part of the public trust. Okay, lawyers play a vital role in the preservation of society. Fulfillment of this requires the understanding that lawyers and the relationship, the legal system, the rules of professional conduct when properly applied serve to define that relationship. Scope. Now, when I, like I said, in '79, between the scope and the rules, there used to be the probable clause, the informed consent clause, and it clearly stated, they took it out. I threw that around a lot too. In order before anything can proceed in any court of law, they must obtain informed consent from you, whoever's in the court of law. In order to get informed consent, you must have reasonable knowledge. You must have how'd it go? You must have reasonable knowledge to make an informed decision. I said you must have reasonable knowledge to make an informed decision in order to give informed consent. And I believe knowing the rules, the codes, the legal obligations of all lawyers and judges in a court of law to the general public in general, would be, in part, reasonable knowledge to make an informed decision, to give informed consent. They took it out of here, but I did a video on where it's at, okay, and it's still here, but it was specific. It was very specific, and they took it out. I've been throwing this around since 1979, and they keep taking stuff out. And I just told you that was in the interest of the bar. That was so I couldn't use it against them. And I've been teaching the people along the way since 1979. Not a lot of people listen, but some people listen. And I've been throwing things in court, finding things in court since the 80s, 82, I think, and beyond. Even while I was incarcerated, I was throwing things at the court, going at it with the lawyers that were supposed to be representing me, who weren't doing any of this. And I wanted to be remanded to court, and I challenged the double jeopardy clause, and they heard me out on that. That was the only thing they did for me. I clearly pointed out a conspiracy, deprivation of rights to deprive me of my constitutional right to effective assistance of counsel, a fair trial, a quick and speedy trial, due process in general, and I proved it. Nobody abided by the rules. Nobody abided by the codes. The judge didn't cite the attorney either side. He didn't cite my attorney for ineffective assistance of counsel. He didn't cite the state's attorney for prosecutorial misconduct. Violated the rules in its entirety, starting with Rule 3.8, special responsibilities of the prosecutor. Violated that in its entirety. They ignored all that. My proof of the conspiracy to deprive me my constitutional rights under the color of law. Another color of law is a simple term meaning that they got away with what they got away with because everybody thinks it's legal, but it's not actually legal. They're just making shit up. Look up under the color of law. That's what we're all living under. We're living under the color of law. Ever since the Constitution was written, we've been living under the color of law. I mean, it says Constitution, the law of law, the rule of law, the king of laws, the most poetic version ever written of it. You know, as I said earlier, in the nation of laws where it says that every man is created equal. Let me reiterate, everyone is created equal and endowed by their Creator with certain inalienable rights. Among these are life, liberty, and pursuit of happiness. And nothing quite says diversity, equity, inclusion quite like our nation's creed. The motto of the United States Constitution and the Declaration of Independence. Well, either way, but you go over any of the preamble and you'll see that none of this is happening. None of this is happening. You know, that's what I've been teaching people. And if you can understand anything I'm saying, you can understand the rules of professional conduct. It's in layman's terms for the most part. And most people say they can't understand the law because you're listening to the lawyers talk to you. And they use a language you can't even understand. You literally have to go to law school to understand the language they speak. But to understand the rules, the codes, the laws within a court of law. I mean, look at it. It says, let me go over 8. Lawyers' responsibilities as a representative of clients and officer of the legal system and a public citizen are usually harmonious. Thus, when the opportunity party is well represented, a lawyer can be a zealous advocate on behalf of a client and at the same time assume that justice is being done. You know, that's the spirit of the law right there. Seeing to it that justice is being done. That's why I strongly suggest when you refer to the rules and the codes, always refer to the letter of the law. Make sure everybody does this word for word to the letter. So to see to it that the spirit of the law occurs, that justice is being done, the truth is being told. Okay, nothing but love for you. Nothing but love for you, all of you. All of you. The Constitution clearly in the Declaration of Independence, it clearly says that we are all created equal. And that's all I see. When I look at any of you, all of you, that's all I see is we the people. It doesn't matter if you drive a bus, an Uber, a Lyft. You operate the trains that take our freight across America. You operate the ships that take our freight through our waterways. It doesn't matter if you're a nurse, a doctor. It doesn't matter if you're young, you're old. I don't care if you're not old enough to vote. You still have your constitutional rights. You know, I don't care if somebody thinks you're too old and retired and you're living on Social Security. You still have your constitutional rights. And as a United States citizen, when I took an oath when I took a Pledge of Allegiance, I took an oath to the Constitution and who represents we the people. When it comes to we the people, the Constitution, that's the content of my character, which makes the we the people the content of my heart. Many, many pieces of my heart. Okay, people, so when you go over the preamble, you'll find how so many of those laws are broken. And see, when I was talking about diligence, I was looking for expediting litigation, conflicts of interest, duties to former clients. Now remember, communication is required in all of this. Diligence is required in all of this. Okay, so you can't violate any of these without violating other ones. You're required to be diligent in all of this. Okay, organization as a client with diminished capacity. Nobody abides by that. What do? One diminished capacity, they put them conservatorship, guardianship, and then they take everything away from them. But then when they're safekeeping property, they don't abide by that. They don't abide by safekeeping property. They literally lead clients with a diminished capacity dry. So if they're not doing this or this, they're not doing anything else. So they're violating multiple laws. I've been trying to tell people that have been challenged in probate court, they're having to go it alone. Somebody was telling me about an old man that he's in guardianship in its state, and they're bleeding him dry, and the family's trying to get him out of it. But these families don't even realize that nobody's abiding by the laws in a court of law to do this to them. Okay, I mean, this is due process. Due process doesn't exist if they're not doing this. Declining or terminating. I had a lawyer quit on me in the midst of a case, and that's illegal. He has to give me time and opportunity to find somebody to take his place. Sales of law packages, evaluation, meritorious claims and contentions. Here it is, expediting litigation. How often is there diligence? A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. If you fail to expedite litigation, which they all do, your failure at being diligent. That's not competent. That's incompetent. You're required to be competent. Show competence. That's the law. And if you don't, that makes you incompetent. People used to laugh at me in the 80s when I would have shouting contests with the public defender's office. When I would say, so if you're not competent, that makes you what? And I turn and look at it to people. What does that make them? When you fail to be diligent in expediting litigation, did he communicate that it's mandatory? Did he communicate that to you? I says, no, he didn't. So that it would be competent to do so. So if he's not competent, that makes him what? And nobody would say that makes him incompetent. He's at 5, 6, 12 people laughing. And the public defender will walk away. So this is why I've been, meritorious claims and contentions. A lawyer shall not bring or defend a proceeding or assist or convert in an issue therein unless there is basis for law to find that doing so is not frivolous, which includes a good faith argument or extension, modification, reversal of existing law. A lawyer for the defendant in a criminal proceeding or responding in a proceeding that could result in incarceration may nevertheless so defend the proceeding as to require that every element of the case be established. So they can't just make shit up. That's called in civil court. That's called a slap suit. That's what a slap suit is, where people go and make frivolous and fraudulent claims, which is illegal. You can't go to court and make frivolous and fraudulent claims. But a lot of lawyers won't argue. You'll literally have to get a lawyer to go to court and argue that, but they won't say, hey, that's illegal. He can't do that. And it's actually illegal for me to go to court and argue it. I'm supposed to, you know, report this to the tribunal, counsel to the tribunal. Hey, judge, this guy is violating the rules of professional conduct, to bring a claim to the court, you know, that he can't prove. You know, now I could go along with him if I want to make the big bucks. I'll go along with him and we'll argue this out in court. But this shouldn't even go to court. Fairness to the opposing party. That's where expediting litigation comes in. Fairness to the opposing party. Expediting litigation is mandatory. So you can open that up and read it. You know, it'll tell you fairness for shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, conceal a document. You know, everybody does that. And it's illegal, but they'll do it anyways. Well, not everybody, but a lot of people do that. And you know, that's what I've been trying to teach people, especially in criminal cases. But it doesn't happen just in criminal cases. It happens in cases where they're doing guardianship and probate. You know, taking children away from their parents away from their children. You know, I mean, people literally are getting their kids taken away by somebody making a frivolous and fraudulent claim, something that can't be proven in a court of law. But a judge will allow it to happen because there's money to be had taking them kids. And people that they do it to, they say, well, we don't have to give you an attorney because that's only in criminal cases. But what they're doing is criminal, taking your children away from you and expecting you to abide by the rules and codes and follow the procedures in court, and you're not a seasoned, educated professional. You lack the tools. That's like sending a Cub Scout to fight the Ukrainian war against the Russians with a rubber knife. And I find that upsetting. How is that a fair trial for you or your child, or for your parent who wound up in guardianship or probate or behind bars? It's impossible to violate one rule without violating multiple rules, and that goes in every court of law, state, federal, even in traffic court. Well, at the traffic court, the judge wasn't having it, but they threw out all my tickets because they didn't like having to come out of whatever they were doing and sit in the court. I was the only one there. Impartiality and decorum towards the tribunal. A lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. Communicate ex parte. They always communicate ex parte with such a person during the proceedings unless authorized to do so. A lawyer by the court communicate with a juror, prospective juror, or discharge. If communication is prohibited by law, it's you know, there's a lot of stuff you don't know because you're a layman. Trial publicity, that's going off a lot, so you might want to check into that. Special responsibilities towards a prosecutor. I've been trying to overturn wrongful convictions since the 80s. And that's why I, you know, sometimes when I file with the ARDC, Attorney Registration Disciplinary Commission, and the Judicial Inquiry Board, now it's the Illinois Attorney Registration Disciplinary Commission and the Illinois Judicial Inquiry Board, but still the same. And sometimes I would attack the state's attorney first. Special rules of the prosecutor. Okay, And you'll find that some of this that is put it in here is also in the preamble, but it's a special reminder to the prosecutor. And for some reason, they always got to remind the prosecutor. Special rule, Rule 3.8, special responsibilities of the prosecutor. The duty of public prosecutor is to seek justice, not merely to convict. The prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So why doesn't the public defender and the judge, why don't they like probable cause hearings? That rarely happens. There's one judge I've seen on the internet, marvelous gentleman. He knows nobody's going to put that out there. The courts require probable cause hearing. And this is why. This is why this judge is doing this. Okay, but he's the only one that I've seen that's doing it, abiding by the law. And it's the duty of the prosecutor, so he's doing the prosecutor's job. He's stopping the prosecutor from breaking the law, violating Rule 3.8, special responsibility of a prosecutor. He knows the prosecutor is breaking the law, and the prosecutor knows the cop broke the law by arresting these people. That's violating the oath. And remember, violating the oath is punishable by fines, removal from public service, and incarceration. Judge didn't mention that, regretfully. Okay, a prosecutor, criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Okay, make reasonable efforts to ensure that the accused have been advised of the right to and the procedure for obtaining counsel has been given reasonable opportunity to obtain counsel, not to seek or to obtain from an unrepresented accused a waiver of important procedural rights, such as a right to preliminary hearing, make timely disclosure to the defense of all evidence. Timely disclosure. That means they must be diligent in expediting litigation. It should be from the jump. Any evidence they have, as soon as they have it, they make a copy. When they go to court, they walk across the table and hand it to the defense. And remember, in fairness to the opposing party and counsel, a copy must go to the opposing party as well as counsel. The opposing party, which is you, is entitled to disclosure to its fullest extent. That's, the file, anything and everything that they're going to use, as evidence against you, you are entitled to that. And that doesn't happen. See a man on TV get out of prison after 40 years. They gave him a retrial. They gave him discovery. They gave him discovery when he opened up the box. And there it was, exonerating evidence on the top. He disclosed that to the attorneys that were representing him, that were trying to get him out. I think it was through the Free Thought Project. And he was exonerated. It was there the whole time. It's just that nobody brought it up. Not to seek to obtain from unrepresented or accused person of important pretrial rights. I got arrested. Assistant state's attorney came in, and she said she had papers for me to sign. I didn't know what I was talking about. I don't even know why I'm here. Cop pulled a gun out on me, said, "You're arrested," brought me here, beat the crap out of me, tried to get me to sign a confession. They're mad because I didn't. I said I wanted an attorney. They laughed at me, and now here you are. Who are you? Are you this Are you a public defender? I have a lawyer. I gave him his name and phone number, told him I wanted my lawyer. And here you are. Who are you? Turns out it was assistant state's attorney. She didn't tell me. She got mad, walked out, yelled at the cops, the detectives, and stormed out. And everybody was pissed because it was said that I was going to sign a conviction. They beat me pretty bad. Or sign a confession. And the confession would have led to a easy conviction. And actually, when I went to court, they tried to convince me. The lawyer that replaced my lawyer tried to convince me to take a plea deal. No, I didn't do nothing. But either way, he kept saying that if I didn't take a plea deal, the state's attorney would initiate more charges, throw more charges, add on, throw some weight. So I wind up doing a substantial amount of time until I mentioned violating the double jeopardy clause. You can't try, convict, even charge anybody multiple times of the same crime. Pick a charge. Pick a law. All right. Make timely disclosure to defense of all evidence. Not subpoena a lawyer in a grand jury or other criminal proceedings to present evidence about past or present client unless the prosecutor reasonably believes the information sought to protect, disclose. Okay, well, there's a lot they don't do, but I want to get down here. Not subpoena a lawyer. The evidence sought is essential to successful completion of ongoing investigation. So it's their duty to disclose everything, even if it means they lose. Okay, except for statements that are necessary to inform the public the nature of extent. Okay, this is why I wanted to go over. When a prosecutor knows of credible or material evidence creating a reasonable likelihood that a convicted defendant did not commit a crime of the offense of which the defendant was convicted, the prosecutor shall promptly disclose that evidence to the appropriate court or authority, and if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose the evidence to the defendant unless the court authorizes delay. All right, and it's quite often you can do it because before, when people were tough on crime, they were tough on crime by not disclosing exculpatory evidence, so they'd make an innocent man look guilty or an innocent woman, innocent child look guilty. For statistical purposes, I'm tough on crime. Look I got a 95% conviction rate, but you got a 95% conviction rate because you didn't do this. And it's the public defender's job to see that you do it, and you don't do it. They don't see to it you don't do it. They don't report you for not doing it to the ARDC or to the judge. The judge knows you're not doing it. The judge is supposed to report you. You're supposed to be disbarred, fined, and incarcerated. Same thing with the public defender and the judge, because reporting misconduct is mandatory, both the rules and the codes. And nobody does it. And talk about ineffective assistance of counsel. That's the ineffectiveness of the court in its entirety. The judiciary in its entirety. The prosecutor knows clear, convincing evidence established that the defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit. The prosecutor shall seek to remedy the conviction. A prosecutor's judgment made in good faith that the evidence not rise to the standard set in this paragraph E shall subsequently determine to have erroneous does not constitute a violation of this rule. Okay, in the comments, the prosecutor has responsibility to administer justice, not merely simply that an advocate. The responsible carries it with special obligation to see that defendant is accorded procedural justice and their guilt is decided upon the basis of sufficient evidence. You know. So it's easy to overturn a wrongful conviction if you use the law. And if you use the prosecutor, if you have exculpatory evidence, I have been questioned many a times of where they can find a lawyer, a civil rights lawyer, to help them exonerate themselves because they have exculpatory evidence. Well, I've only met one lawyer that actually spoke with me in length on the rules of professional conduct and code of judicial conduct, rule of law, letter of law, spirit of the law. And we had a great time. We used to have a great time every time I seen him discussing the law. And we actually joked about it. But other than that, I've had threats made for exposing a conspiracy against rights under the color of law. And that's a legal term, a conspiracy against rights under the color of law. Google where to file or a conspiracy against rights under the color of law complaint form. Type that in. Okay. Okay, now, see, I always found this redundant. The state's attorney's office offered capacity to representative all people, including the defendant. Most people don't realize that, and the state's attorney will deny it, including the defendant. State's attorney is in official capacity, is a representative of all the people, including the defendant, and it is much duty to safeguard the constitutional rights of the defendant as those of any other citizen. People versus Cochran. Okay, in 1935, the United States Supreme Court described the duty of a federal prosecutor in the following passage. The United States Attorney is a representative of not an ordinary party or a controversy, but of a sovereignty where obligations to govern impartiality and as compelling as it is obligation to govern all whose interest thereof is a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is a peculiar and very definitive sense of servant of the law, the twofold aim of which is the guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction, as it is in every legitimate means to bring about a just one. That kind of makes Brady versus Maryland redundant, don't you think? I've used that statute, that precedence, in helping a lot of people. Brady versus Maryland. But I use this and people act like I'm stupid. So, but no, I like the law. I read about this a long time ago. Actually, when I found out about Brady versus Maryland, I dug deeper and I found this. And plus, it was in the rules of professional conduct, in the Illinois rules of professional conduct, which made it real easy. Which, here it is. It's in the Illinois rules of professional conduct right here. Right here. The first sentence, rule 3 reporting, not extend standard, but one good prosecutors will steadily recognize is always adhere to the discharge of their duties, specific standards such as those of Rule 3.3, 3.4, 3.5, 3.6, and remaining paragraphs of 3.8 and other applicable rules provide guidance for specific situations. Rule 3.8 is intended to remind prosecutors that the touchstone of ethical conduct is the duty to act fairly, honestly, and honorably. And that's in every state, y'all. In Illinois, a defendant may waive a preliminary hearing and therefore lose a valuable opportunity to challenge probable cause. People always ask for a probable cause hearing, first court date, first appearance. Always, always, always. That's your right. And then tell the judge to cite your attorney for ineffective assistance to counsel for failure to do so. It's his legal obligation, his duty, as well as the state's attorney and the judge himself. Okay, that's the law. Okay, accordingly, prosecutors should not seek to obtain waivers of a preliminary hearing or other important pretrial rights from unrepresented accused persons. Okay, so you can see why I've always, it wasn't just for me. Everything I've ever done, everything I've ever written, everything I've ever mentioned, every time I've written to a court, appeared in front of a court, I've always spoke on you. We the people. And I'll forever mention what you took from me, you took from me. What you took from one, you took from all. And that's why I'm here. To get it back. Not just for me, but for we. And I want it all. I was a bit of a smartass. I'm not going to lie to you. But I was young, impetuous. Okay, remember I told you about Brady versus Maryland? 1970 Supreme Court case, course plea bargains. January 7, 1958, 25-year-old Maryland man named John Leo Brady and his 24-year-old companion Charles Donald murdered 53-year-old acquaintance. Wow. William Brooke. Both men were convicted and sentenced to death. Brady admitted to being involved in the murder, but claimed that Bobbitt had done the actual killing and that had stolen Brooke's car ahead of the planned bank robbery, but had not planned to kill him. The prosecution had withheld a written statement by Bobbitt that the men were tried separately, confessing that he had committed the act of killing by himself. The Maryland Court of Appeals had affirmed that the conviction and remanded the case for retrial. Only on the question of punishment, Brady's lawyer appealed the case to the Supreme Court for a new trial. Decision: Supreme Court held that withholding exculpatory evidence violates due process when the evidence is material, either or guilt or to punishment. The court determined that under Maryland law, the withheld evidence could have exculpated the defendant and was material to the level of punishment. Thus, Maryland Court of the Appeals ruled and affirmed Brady would receive a new sentencing hearing, but not a new trial. Basically, it's about withholding exculpatory evidence. All right. And if you find that exculpatory evidence, remember it's the state's attorney's job, wherever it happened, to overturn that wrongful conviction. Okay, truthfulness in statements to others. That means no lying. Can't go in there without being able to prove anything. Communication with person represented by attorney. You can't do that. They got to talk to your attorney, they're your attorneys you got to talk to. Attorneys got to talk to attorneys first. They can't talk to a represented person without their attorney present. Respect for rights of third persons. See, people, these are all laws that you should look up in a very convenient place in the rules of professional conduct. Independence of lawyers, accepting appointments, memberships. This is a lot of what doesn't happen. Now imagine if you knew. Imagine if you knew you had the reasonable knowledge to make an informed decision, to give informed consent. People used to laugh at me when some of the stuff I used to talk about. Actually, some said I was a conspiracy theorist, but no, I wasn't a conspiracy theory. I was actually litigating a conspiracy against rights under the color of law. And actually, that's what got me the death sentence. And judge found me guilty, had me taken into custody, was going to give me time for a case that was legally should have been probation. But she was dead set against me from the beginning. And so were the lawyers that were supposed to be defending me. The prosecution knew that there was no probable cause. Matter of fact, in the preliminary hearing, the plaintiff was told not to reiterate her testimony because it would be considered perjury. I don't know why the judge didn't cite her for perjury in the preliminary hearing. The state's attorney for malicious prosecution for violating the rules of professional conduct, because what she said were not meritorious claims and contentions. The state's attorney knew she was going to say that. The public defender didn't object. I mean, talk about impartiality and decorum of the tribunal. Okay. Meritorious claims and contentions. I mean, if that attorney was expediting litigation, I mean, it failed at probable cause. The judge didn't say it. But the main thing was, in that probable cause hearing, the judge did not cite the plaintiff for perjury, but warned her, you say that again, you can and will be cited for perjury. And he kicked it off the trial. But he wasn't the one handling the trial, and for some reason, the state's attorney decided to carry on with the case. And failed to correct any inconsistencies. And the judge and all the lawyers that were supposed to be working for me, and the state's attorney, they all said, all the witnesses that I wanted, the evidence that I wanted. No, the only witnesses the judge was allowing were only a couple witnesses. No doctors, not the cop, nobody mentioned in the police report. No. My word against hers, and in the end, when the judge made her decision, that's what she says. There was no evidence. Who's to be believed? It's his word against hers. And I want to get you into that. All right, because I've been filing, I said, for years, to overturn a couple wrongful convictions. Actually, a lot. Worked for other people, but not for me. Well, because I threw every book at them. All right, so in one of my future videos, that's who I want to go after. Rule 3.8. The prosecutor. And overturning that wrongful conviction. But I want her to take note, and nobody likes me bringing it up. all the violations in the rules of professional conduct and in the code of judicial conduct. Because look, right here, advocate, responsibilities, professional restrictions. Or is it at the bottom, I think? Misconduct. Misconduct. Reporting misconduct. It's mandatory. Who knows a lawyer who knows that a judge has committed a violation of applicable rules of the judicial conduct that raises substantial question of the judge's fitness for office shall inform appropriate authorities, which is the Judicial Inquiry Board, Illinois Judicial Inquiry Board. So violating the rules, the only reason your lawyer gets away is because the judge allows it and the opposing party allows it. They don't report misconduct. That's misconduct. And failure to report misconduct is misconduct. So, I mean, the opposing party, whether it be the state's attorney or whoever, will violate the rules. And the judge will allow, thus violating the codes, and they're interconnected. And you can't violate one code without violating another. It's impossible just to violate one code. So when you violate the rules, you violate the codes. When you violate the rules and the codes, you violate the Sixth Amendment to effective assistance of counsel, and thus denying you fair trial, thus denying you due process. And in the process, you prove that they conspire to deprive you your constitutional rights of due process. Okay. My clock says this video went an hour and 21 minutes, and I don't like to keep you that long. Okay. And if I post this on TikTok, they'll only put an hour of it. So they'll have to go to my YouTube channel. I'm putting this on my YouTube channel. And then on my Facebook, and then TikTok, Instagram, X, wherever I can. All right. But remember, I started legal reform on Facebook, and I'm not trying to get popular, likes. I'm not worried about that, but I'm worried about you, and all of you. And that's why I'm doing this. And I don't charge anybody. The only time you spend at legal reform, the only thing you spend at legal reform is time, no money. I ask for nothing. And I've rejected donations. It's not why I do this. I do this as a father worries about his child. That's why I do this. I'm not a religious person. When it comes to God's laws, there are but 10 of them. Soy no santo. Ay, Dios mío, soy no santo. But I do my best to follow in the footsteps of Christ. No, I'm no saint. My God, I'm no saint. I am but a man. I am as He created me, human. And I'm doing as He created me to evolve. And the evolution of man is to recognize there is but one planet, one earth, one race, one love. That's the love I give. Step 12. Nothing but peace and love. Thank you and good night.